SJC-13756, Commonwealth versus Daryen T. Robinson.
Okay, Attorney Levin.
Good morning. May it please the court, Patrick Levin on behalf of Daryen Robinson. There's a lot going on in this case, so I'm planning to address the suppression issue and the Batson issue, and I'll rely on my brief for the remaining trial issues unless the court has burning questions about them. To begin with the motion to suppress, this case arises from a routine traffic stop for tinted windows, but Trooper Jafar's conduct during the stop clearly demonstrates that he was never interested in enforcing the window tint violation at all. The very first thing that his testimony at the hearing, for that matter, makes clear that he immediately developed a hunch that these two men were involved in drug dealing activity, and his conduct throughout the stop from the very outset makes clear that he is conducting a criminal investigation based on that hunch, not conducting a traffic stop. The very first thing we see him do in this body cam video is tell Mr. Robinson, I don't need to see your registration. I just want your driver's license.
But doesn't he also smell marijuana?
Yes, Your Honor.
Okay. There is something in addition to the tinted window that he wants to investigate.
Well, he smells unburnt marijuana is the testimony, which of course is a legal substance.
But not if you're under 21.
That's right. And so the second thing that he does is he pivots to an investigation of the passenger, Mr. DiMederos' identity. And the only basis that he has ever offered and the only basis that the Commonwealth has ever offered for him to conduct that investigation is to find out whether Mr. DiMederos is under 21 and therefore not permitted to use marijuana.
If he looked like he was 14 or 15, would that, what could the police officer do in that case? I understand this guy may look 27 or 30, but say he was a kid.
Well,
could you prolong the investigation at all for that, or what?
So if he's clearly a child, I'm not sure that it's reasonable to believe that the smell of unburnt marijuana relates to him at all if there's an adult in the car.
If he's 15 or 16.
Well, in that case, Your Honor, obviously my argument is that there is no authority for a police officer to impose on a citizen's liberty solely for the purpose during a traffic stop in particular, solely for the purpose of investigating a civil marijuana infraction. This court's cases make clear that in order to issue an exit order during a traffic stop or in order to initiate a traffic stop in the first place, reasonable suspicion of a civil marijuana infraction is not sufficient. So the answer to your question, Your Honor, is if it's clear or relatively clear that the person is underage, then probable cause would arise.
You're conflating the exit order with the prolonging of the window tint stop. So we'll get to the exit order in a second, but as far as prolonging the window tint stop, it's a civil offense under 32L.
Yes.
And they're subject to a penalty of $100 and forfeiture of the marijuana.
That's right.
So in Justice Kafka's hypothetical, were the person to be very young looking, and we'll get to whether it's clearly erroneous the finding the judge makes, but were the person to be clearly 18 years old, would the police officer be able to extend the traffic infraction to forfeit the marijuana? So
the relevant line is the line between probable cause of the infraction and no probable cause of the infraction. If there's probable cause, then he's allowed to issue the citation, he's allowed to seize the marijuana, and obviously in order to do those things, he's allowed to extend the stop.
And check the age, correct?
Right, yes. If there's no probable cause, then he's not entitled to impose on these men's liberty in order to investigate the basis of this court's opinions in Cruz and in Rodriguez and in Cron is that this is not consistent with the intent of those ballot initiatives that we're treating.
Just so I'm clear, Mr. Levin, your argument is that there was no probable cause to investigate the marijuana licensing issue.
Yes, because this man is 27 and he looks 30.
All right,
I mean,
so that's the issue then we have to find that the judge was clearly erroneous because he makes a finding that Jeff asked for identification to confirm their ages due to marijuana use, right?
So that's his finding, and I'm not arguing that there's error in the finding that that's why he asked for the identification. In terms of the standard of review of that finding, I think you can look at the video and decide for yourselves if, how old does this guy look? And so that's a de novo standard. And I would say, the Commonwealth.
We would have to find not only that we thought he was 27, but that the motion judge was clearly erroneous in thinking that the officer could reasonably think he was less than 21.
So I don't agree because the reasonable suspicion standard is a legal question. So the question is on the facts that were available to the officer, was there probable cause or not? And so you can look at the video.
It's reasonable suspicion to investigate, right? And then
reasonable suspicion of a crime, Your Honor. He needs probable cause to investigate a civil infraction. So that's the holding in Cruz and that's the holding in Rodriguez, is that the legalization initiatives, and I want to note that those cases predate the actual legalization of marijuana for recreational use. And so in those cases, possession of any amount of marijuana continued to be illegal. It was still contraband.
So again, I just want to make sure I understand that. So even though reasonable suspicion allows you to continue it in a criminal investigation, we don't have that reasonable continue when we're dealing with civil. It has to rise right to probable cause.
Yes, I think that's the clear import of this court's holdings in Cruz and in Rodriguez.
But you're not arguing that in and of itself, the civil marijuana infraction cannot extend a traffic stop.
No, I'm arguing that in order to extend a traffic stop based on a civil marijuana infraction, there needs to be probable cause of the infraction.
All right, thank you.
And the Commonwealth's view.
I understand in Justice Botsford's decision, and I can't remember what the name of it is. She says in order to arrest for that, you need the probable cause. But does she directly address the issue we've been talking about?
So, Your Honor, the cases I'm relying on don't involve arrests. The Cruz case says you cannot issue an exit order based on reasonable suspicion of a marijuana infraction. And the Rodriguez case says you cannot initiate a traffic stop based on reasonable suspicion of a marijuana offense.
Right.
And I just want to,
again, we're sort of in a gap, aren't we? Because we have reasonable suspicion to stop the car because of the tint. And then the question
I think there's probable cause probably on the tint.
I'm not worried about that part of it. But then it's that issue about can the officer continue to question? And you're saying he can't continue to question unless he has probable cause when it's civil. I don't know if we've ever expressly stated that in a case, have we?
Well, that's what Cruz says, essentially.
Okay.
That he can't depart from the purpose of the traffic stop, the enforcement of the traffic laws, without probable cause of the civil infraction or reasonable suspicion of a crime. On the facts in terms of whether there is probable cause or not, the Commonwealth's position essentially would allow any person under the age of, say, 35 or so to be stopped and carted on their way out of a liquor store or a dispensary. And that is an invitation to the kind of dragnet interrogation that our Constitution forbids.
Does it matter that, I'm sorry.
No, please go ahead.
Does it matter that there was already a reason to stop the car?
No, because the reason didn't have anything to do with this individual. The reason was just what the Torres case says and the Gonsalves case says is that a passenger in a stopped car has the right to expect that the formalities of the stop will occur only between the driver and the officer, and that the officer doesn't get to interrogate passengers, doesn't get to demand identification from passengers without some independent basis to believe that the passenger is engaged in criminal conduct.
Mr. Levin, what do we do with the exit order where the judge didn't address it?
I don't think you need findings from the judge to see that there is no possible basis for this exit order. And the Laughlin case says that when you're analyzing the validity of a consent that is obtained following an unlawful exit order, the test we use is the same test we use to analyze the admissibility of a confession that is obtained following an unlawful arrest. And so that's the standard attenuation test. And you look at the attenuation factors, there's no time lag, There's no, intervening circumstances here. And in terms of purpose and flagrancy, we actually have testimony from the officer at page 24 of the hearing transcript that he got him out of the car for the purpose of getting his consent to do the search. There's clearly no attenuation here. The purpose of the exit order and the effect of the exit order was to obtain this consent.
Do we look to see the severity of the crime that the passenger is being arrested for?
I mean, that's certainly relevant, I think, to whether there was any reason to issue the exit order in the first place. And of course, what we have here is a years-old default warrant on a district court shoplifting case. So that I haven't ever seen any real, genuine argument from the Commonwealth to explain why anyone would think Mr. Robinson was dangerous and that this exit order would be justified. So I think that's an easy question, frankly.
If you don't mind, can we move to the jury selection issue?
Yes, Your Honor. Okay. So in terms of the standard of review on the jury selection question, I think it's very clear in this court's cases, Burnett, Maldonado, and Benoit, that implicit findings about the basis for a peremptory strike do not receive deference from this court. There needs to be an explicit finding on the record, separate findings both as to the adequacy of the prosecutor's explanation for the strike and the genuineness. Here, we don't have a sufficient finding on either for this court to defer to. All that the judge says is, I'm satisfied with the Commonwealth's explanation based on the occupation, and the fact that he also exercised his peremptory strike on the other juror supports the reason. That's the extent of the finding. But that finding, to the extent it is a finding, is made well after it's actually too late to sustain the objection and seat the juror. So I think, at least under the appeals court's decision in Commonwealth versus Douglas, it's very clear that that is not good enough. You need to make the finding while you can still sustain the objection to show that you actually have considered the relevant factors before you overrule it. So there's no deference to this judge's finding here. So this court has to make its own determination. Is the explanation of, I don't ever seat engineers on my juries because they follow the rules and they think in black and white, is that an adequate explanation for exercising a peremptory strike when the judge has made a finding of a prima facie showing that the strike
Especially here, it's easier for you because he doesn't strike the mechanical engineer. He only strikes the other engineer. So
That's right, Your Honor. And so I think that certainly
I don't
goes.
know that that's so easy, though, because we have the questionnaire in the record appendix, and I know that you brushed this off, but the engineer that the Commonwealth sought to exercise the peremptory had a lot more meat in the questionnaire, talked about his education and what specifically the role did versus the other where it was just a conclusory statement that you could see that, I know you criticize the genuineness of it, but when you look at the explanation from the Commonwealth about, well, this is clearly somebody who's dressing up what he actually does, and I can read in between the lines versus this other person who actually says, here's my background, here's what I do, it includes coding. Why does that really help you to say that that's not really genuine or adequate? And I'll add one other thing. If it's a categorical approach that the Commonwealth took to striking this person and using the peremptory, why is that so different than the categorical approach the defense lawyer took when it came to law enforcement? Because the defense lawyer did the same thing.
So there's two separate issues there. On the second issue, I think respectfully that's not an accurate reading of the transcript. The defense lawyer struck the law enforcement officer not on a knee-jerk reaction that he had any relationship to law enforcement, but because his brothers were members of the Taunton Police Department and the State Police Department, which is the very police department that he's going to hear testimony from the officer in this case. And B, he says during the voir dire, I never talk about work with my brothers. And she's very clear, I don't find that plausible, and therefore I'm not comfortable with this juror. So I don't think it is a blanket rule. In terms of whether a blanket rule is okay, I do think that this court's decision in Commonwealth versus Maldonado makes clear we're not going to follow Perkett versus Ellum. We're not going to follow the federal law in this area. We are going to require an adequate reason, and an adequate reason means a reason that is related in some way to this case. And you can see that in the Massachusetts case law. You can see in...
When I get back to the mechanical engineer, though, Justice George has read this more closely, the underlying documents, but what does it say about him being a mechanical engineer? Is he an engineer or is he a mechanic?
He's not a mechanic. He's a manufacturing engineer at a major medical device manufacturer. He designs the production line. This is not, you have to...
And that's clear in the paperwork.
Well, it's clear that he's a manufacturing engineer. And to the extent that it's not clear exactly what his job was, if this prosecutor has a policy of, I never seat engineers on my jury, the thing to do is to ask him questions during the voir dire. That's the whole point of having the voir dire.
Didn't he say that he missed that one? I mean...
Well, first he said he missed it, and then he said, I seated him because he's a manufacturing engineer. So that doesn't add up.
Well, it's also inconsistent with the policy that the prosecutor said he had of eliminating all engineers.
Right, and
as he hears that word in the job description, one would think, aha, I have to eliminate all engineers.
Right, and you see that the policy, it changes a little bit over the course of the colloquy, because first he says, I never seat an engineer on my jury ever. But then once he realizes that he already did seat an engineer and someone has pointed that out to him, he says, well, I almost never
But
seat.
does that go to the adequacy or the genuineness?
So that goes to genuineness. And they are two separate inquiries. I do see that my time is up, so
I think we're going to give you more time.
Okay.
So I don't see how we can do a de novo review of genuineness here when we've got this sort of muddled, inconsistent explanation, and then the resolution is because he's pressured into striking both. I mean, I don't.
So if you look at the case law, the outcome of these types of cases is reversal, where it's not, there's a muddled, inconsistent explanation. The reason for the strike is not totally clear. There is a prima facie finding of a racial motive. And, we know during this jury selection that the race of the jurors has been salient, particularly salient to defense counsel. And, whether the prosecutor genuinely thinks that Black jurors are going to be worse for him, or whether he just thinks my opposing counsel thinks that an all-white jury would be bad for her, and so that's what I want, that doesn't make a difference. He's not allowed to strike people based on their race. And so we have, the prima facie showing certainly is well supported here that the judge makes.
Can I ask you about that? Because you said on the adequacy showing and the genuineness showing that we can't defer to implicit findings. Can we defer to implicit findings on the prima facie conclusion by the judge? Because the judge doesn't really say that. I mean,
this immediately follows a separate Batson objection that is raised to a cause challenge. And you can see in the back and forth, the judge eventually says, look, I'm denying the cause challenge, so I don't need to reach the Batson issue, but we can get there if he tries to exercise a peremptory. And then he immediately exercises a peremptory on this other Black juror. She makes the Batson challenge, and the judge immediately says, okay, I want an explanation. That's hardly even implicit. Like, you can see that she thinks that...
Well, you're breezing through all of this stuff, and I don't know that you can, because that's also kind of just not even paying attention to what seemed to be the core of the prosecutor's issue, and that was language. And I didn't even I couldn't even tell from the record whether or not this juror was actually Black. The juror talked about being of Cape Verdean descent, and so I don't know what that means, that it could be dark skin, light skin, medium skin, but the point here is the prosecutors seem to be really focused on whether or not this juror was going to be able to understand the proceedings. And so the kind of breezing through and saying, well, there was a prima facie showing here for Batson's sword. I'm asking you, using your own rubric, is there an explicit finding here to move on with that inquiry?
So a couple things about that. First, in direct answer to the question, is that what this court's cases say, and I believe the federal cases also say this, is that once we're on to step 3, we're not going to go back and revisit the step 1 question. That plays into the overall analysis of whether the discriminatory intent has been shown at step 3. It's a totality of the circumstances analysis at step 3, and so all of that stuff is relevant. But the court doesn't go back and look to the step one finding once step three has been reached. But the other thing I would say about that is just to say that I think that that language concern that the prosecutor expresses is a nice contrast with I never seat engineers. That would be an adequate basis for a peremptory strike that could overcome a Batson challenge if the judge believed that it was the genuine reason, because it is related to the case. And he says there's going to be some expert testimony. I'm concerned whether she'll be able to understand all the testimony in this case. And whereas for the engineers, he says, I never seat engineers on any of my juries. There's no way that can ever be related to any particular case.
I have a question about what I understand to be an attempt by the judge to test the genuineness of the prosecutor's explanation by asking whether the prosecutor would be willing to strike both jurors.
Mm-hmm.
And my question for you is twofold. The first is, why is that impermissible? And the second is, in your research, have you found any set of facts that looks like this?
I don't think I've ever seen a case like this.
Federally? Did you look federally?
I mean, I've read some federal cases. I didn't spend a lot of time looking for this particular fact pattern, partly because the federal analysis isn't the same as our analysis under Article 12. I think in many jury selection processes, the way it works is that each juror comes up and you exercise the peremptory or not, and then you move on to the next juror. And so this idea of going back and striking a juror who we've already passed doesn't really come up. Particularly in Massachusetts, I think it tends to work that way. In other jurisdictions, they do other processes. So it's certainly unusual. And I just would say, I think the amicus brief is quite persuasive about why this is impermissible. That, you have to look at the reasons he gives for challenging the particular juror at issue here. And, I think we would have a different case, certainly, if when defense counsel had said, but wasn't the last juror an engineer, if the prosecutor had said, I didn't notice that, obviously I will also strike him, and then everyone had moved on, that's a very different case. I still think there's a question about whether the fact that he didn't notice that a white juror falls within this blanket policy of never seating engineers on his juries, but he did notice it with the black juror, whether that is a result of implicit bias, of enhanced scrutiny applied to the black jurors as opposed to the white jurors. But obviously that's not what we have in this case. He resists striking the other engineer. And so regardless of, what you think of the judge's initial instinct.
So I take it what you're saying is it perhaps may not have been an impermissible technique, or it may have if it had come up spontaneously by the prosecutor because of an oversight, may have been okay. But in the circumstances here, it was not, because it revealed that the prosecutor's reason was not genuine. So
yes, and I think certainly under federal law, I think if the judge credits that immediate, I didn't notice that, and I'm going to strike him too. If the judge credits that, certainly that under federal law probably would suffice. I still would argue under state law that this is not an adequate explanation under this court's cases.
Okay, thank you.
Thank you very much, Your Honors.
Attorney Eisenhower.
May it please the court, Rachel Eisenhower for the Commonwealth.
Will you start with the jury selection since we're
in the jury selection already? Both sides agree that this is not an ideal record, and this is not the record that this court's decision.
Is it an adequate reason to strike all engineers? That's my policy. How does that relate to the facts of this case?
So the way I understood—
Full disclosure, I was an engineer.
I understand
And
Justice
married to an engineer.
And as you know, as an engineer, there are multiple kinds of engineers. There are multiple specialties within engineering, and not all engineers are the same. So for instance, even different—
How is that helping your case?
So
The prosecutor says, my policy is to strike all engineers. How is that tailored to the facts of this case?
So this prosecutor, and I cited prosecutors from other jurisdictions who share the same belief about engineers being difficult jurors for the Commonwealth or for prosecutors. And I believe it has to do with the beyond a reasonable doubt standard. And their belief is that engineers equate a beyond a reasonable doubt standard to a geometric proof. And if the Commonwealth does not make a perfect geometric proof that scientifically proves the guilt of the person, they are likely to acquit.
Okay, so now the prosecutor, assuming that's the reason, because it's not in the record.
That's not.
But that's the reason. Why is it, why doesn't you fall into the other problem of genuineness, where he let juror number 8 go?
Because, as I was starting earlier, not all engineers are what he means initially when he says, I have a policy of not seating engineers. He means I have a policy of not seating what he believes to be a true engineer, someone who engages in either coding or other scientific thinking that would lead them along a set of assumptions and conclusions that would...
A manufacturing engineer, I suppose, then would not fall into the type of engineer that all other engineers fall into? Is the genuineness argument?
He believed him not to be an engineer, but a mechanic. Now, candidly, I know that even within a manufacturing engineer.
It said manufacturing engineer.
It said manufacturing engineer.
And from that he took, because they both start with M, that he was a mechanic?
Well, he did, I believe he did say in the transcript, I interpreted that to be a mechanic. So he did.
I understand. So
way.
I'm testing the genuineness. That's the trial judge's job, right? To test the genuineness of that explanation.
And here, because the judge made no explicit finding on de novo review, that is now the job of this court, if possible, to test the genuineness.
And your argument is that a manufacturing engineer could reasonably be believed to be not the kind of engineer that would push the prosecutor to a geometric mathematical proof level, but would be able to accept the beyond a reasonable doubt. That's the argument.
That's the argument.
How can we do that on a de novo? We're going to be able to do that when he's all over the place on this issue and there's no real scientific basis for distinguishing a manufacturing engineer from another kind of. We're going to do that on our own without any findings from the judge?
I acknowledge, Justice Kafka, that this is a difficult task. And in setting it as a task for the court, I'm relying on the court's prior case law that says the absence of, if the court denies this at step 1, there's no fixing it. If they move to step 2 and the explanation's been given on the record, then it's subject to de novo review. Now, this case tests that premise. Is it really possible? And the prosecutor put his beliefs and his findings on the record. And for
he did, but the judge didn't. And we don't.
And yet the judge
is the one who we've.
And whose burden is it at this step?
Oh, what do you mean? What's the outcome if we can't figure it out?
Well, who bore the burden at step 3 of providing the explanation?
Well, at step 2, it was the prosecutor's burden to fully put the explanation on the record, and then the judge's burden to make findings. And so I'm not quite sure whether, you could say if we don't have enough to review this on de novo review, you could put it a little bit to the prosecutor on step 2, but also a little bit to the judge on step 3.
What do we do with the fact that the judge said, you've got a problem, dear prosecutor, because you left juror number 8 on there and he's a manufacturing engineer. Let's cure it by you striking juror number 8. And then the prosecutor's like, I don't really want to. I want to use my peremptory in a different way. And then the judge says, you got a problem. And he says, okay, fine. If she's going to call me a racist, then I'm going to strike juror number 8.
Okay, so there are many components to the conversation there. I don't think it was appropriate for the judge to require the Commonwealth to use the second peremptory to sort of brace up the first. First of all, because you can't brace up the first peremptory. It has to stand on its own. It can't be braced.
But in terms of our de novo review, which I agree with Justice Kafka is difficult, the fact that the judge said, you got a problem, dear prosecutor, unless you cure it by striking juror number 8, suggests that the genuineness was called into question and was not accepted.
So, and yet, if that had been an actual determination on genuineness, they should have stopped there. So if the judge had not been willing and open-minded about the genuineness, that would have been the end of the story. And I
That's assuming that she didn't err.
Well, even assuming that she made an error, and she clearly made an error because she didn't make the appropriate findings, which she should have. The question is, how could a judge let a lack of genuineness pass? It's beyond a mistake of law at that point, and it's very difficult for me to see how that would happen.
It's just an error. It would be an error, which happens.
Can I ask about the traffic stop?
Can I just ask one more question about adequacy? You said that engineers, the reason to keep all engineers off is because they expect or want to get to something that's more than beyond a reasonable doubt. But is that something that we can do now? I mean, judges, all that any juror has to do is say that, yes, I can follow the rules. I can hear the evidence and I can listen to the judge's instructions. And as long as they say they can do that, engineers should be on the jury just like everybody else. So how is that adequate? How is that an adequate reason?
So in any peremptory strike, the prosecutor is making judgment calls about what kind of people may be more or less likely to make determinations. Now the engineer example is unique because at least under this expression, which was not unique to this prosecutor, it goes to the criminal standard itself rather than the evidence in the case. And the question is, I'm sorry, I completely lost my train of thought.
So the question is,
how can we do
if
that?
the prosecutor believes that no engineer is going to be, or at least the type of engineer that he wanted to strike is the type of person that he wants on the jury, how is that okay if you're taking out a whole class of people in the community who cannot be on this prosecutor's juries? That sounds like that's...
So it is an entire profession.
Right.
But profession is not a suspect class. So clearly that would be a problem if it were race, if it were gender, if it were perhaps religion. I'd have to think about that. Anything in Article 1.
Haven't we said that about age?
I'm sorry.
That age is in a protected class?
Age. Yes, age. But
even if we're not talking about protective classes, I believe we said in Williams that if a person says that they can hear the case and follow the judge's instructions, then they should be able to be on the jury.
So there's a quote from a case, and I apologize, I can't remember the name, but it said, condemned to the use of words, we can never expect mathematical certainty from our language. And the jury instructions are given to everyone in the same language. People with different backgrounds will hear the same words and will conclude different things. And what the prosecutors who adhere to this anti-engineer philosophy believe is that engineers will hear the reasonable doubt instruction, hear those words, and come to a different conclusion than other jurors who are not engineers.
So they won't pay attention to the judge's instructions.
They will pay attention to them, but they will understand a different meaning from them.
But not if they're manufacturing engineers.
But not mechanics, which is what he rightly or wrongly believed the manufacturing engineer to be.
Okay, thank you.
Let me ask you, how do you justify the exit order?
The exit order? So the exit order is part and parcel with the request for the consent. And as you noted, the judge did not address it separately. It does not result in itself in any language, but he gets him out of the car and immediately asks for consent, and he gives his consent.
It's not part and parcel. There's an exit order and then a request for consent. You need two different things. So assuming that the traffic stop was lawfully extended to the check for the civil motor vehicle, the civil infraction of
Then-
marijuana?
Under the law, there would be 3 possible justifications for an exit order. Officer safety, we have no express finding by the judge that the exit order was for officer safety. However, there are some facts there that on a de novo review, you could look to for possible officer safety. He did
The shoplifting default warrant?
definitely, probably not the shoplifting default warrant, but the fact that he believed DeMedeiros was intentionally hiding his name may have made him feel at risk.
But that's not the defendant, right? Didn't we go through this in Sweden Bailey as to?
Yes,
We're focused on the person who's.
Yes,
Or-
but the passenger is already in the cruiser at this point when the driver has the exit order. So
right, so
yes, it's very.
Case is on scene, right, already, so it's 2 against 1 at that point.
Oh, yes,
Okay.
yes.
So we have, all right, so we have officer safety. What's the second?
Yes,
reason?
and there was no finding on officer safety, and we didn't urge it on appeal, though there are some limited facts. The second issue would be probably.
Factually,
I'd just like to go
Yes,
through the
yeah,
three,
go
three things, please.
that was,
And
All right, number 2 and 3.
the second thing I believe is probable cause of a crime. We do not have that at this point in time. And the third thing would be an independent reason for a search.
All right.
And we don't
no
have any
reason
of
for a
those.
search, right?
No, we do not.
That's
have
strike
those.
1, strike 2, strike 3.
That
What justifies the exit order?
well, then there is no justification for the exit order, as you have just proven. However, the recovered drugs did not flow from the exit order. They flowed from the consent, and I don't believe
But
that.
wait, I'm sorry, Justice Graziano, there's a pat frisk that happens then.
Yes, that also.
Justifies that.
Well, if the exit order were okay, the pat frisk pat frisks happen with exit
So in
orders.
this context, there's the illegal exit order, the illegal pat frisk, then can I search your car?
Yes, and you can observe his demeanor on the body camera
So
footage.
now we're into attenuation.
So now we're into attenuation, and it is shortly thereafter. So this is not the kind of attenuation factor where we can look to time, but we can look to his demeanor, and his demeanor, it does not betray any sort of hesitation, any sort of fear. Now, the amici suggests that nonetheless, there may be social science reasons that people consent, and that would have been interesting to litigate at the trial level. But
even more than the social science part, because I'm struggling with which part of this did you say is attenuated? Because he pulls him out of the car and says, I just want to talk to you. And if you look at the body cam video, the conversation is about DeMedeiros, right? Wants to talk to him about that. So ostensibly he pulls him out to talk about the other guy. And then he says, I want to search the car.
yes,
So there's that search. That search then results in the pills and some drugs, right?
yes,
And then Robinson is put into custody.
yes,
Okay. Now, the penultimate thing that he's charged with is the gun that is found after he's in custody. And Jafar says, I want to keep searching. And he says, go ahead. How is that attenuated?
Oh, I didn't believe that was a second consent. I believe that the search for the gun is now justified by the discovery of the drugs, which creates independent probable cause.
Then if that's the case, why ask?
Politeness, but I was not resting on the consent once he was in custody. I'm only looking to the first consent where he says, sure, go ahead. And there's the business about the passenger side.
So you're separating the two?
Yeah, I was not, I had not argued that the second request for consent was a request for consent.
Okay.
We simply didn't litigate it that way.
Okay.
That second one was on pure probable cause after the finding of the drugs.
Just George, you don't. I have one fact question, then I want to go back to a legal issue, which is, the fact question is, when does the Rhode Island, he's got Rhode Island criminal activity at, when do they learn that? I found that hard to follow.
So if it's in the body cam video, the way I understand the video is that he's learning it when he has the license from the driver and he's back in the car. And you can actually see on the video that on his screen, you can't read what it says, but you can see the picture that matches the defendant pop up on his screen at one point. And that's my understanding of when he got that information, which I interpreted from the body cam to be about the driver, but the motion judge said that it was ambiguous whether that comment about the Rhode Island record was about DeMedeiros or about the driver.
But is that before the exit order? Or
That's before.
They have the Rhode Island information before the exit order.
Yes, he does have the Rhode Island information at that point.
And then I want to go back to the legal issue that Attorney Levin argued, that when we're dealing with civil infractions, you can't continue the conversation based on reasonable suspicion as we do in criminal, when we're investigating criminal activity. But when we're doing civil, we need probable cause to continue the discussion. Do you agree with that, or you disagree with that? And what cases should we be looking at?
Well, I agreed with what he cited, that in a different scenario, if it's just smell of marijuana or something, I'm trying to think of a good example. If you had reasonable suspicion but not probable cause of a civil infraction by a person whose identity was known, I would agree with the premise that you need probable cause for a civil infraction. You can't just have reasonable suspicion for a civil infraction. I think
To issue the citation or even ask the question?
Ask the question, yeah.
Because I thought Attorney Levin's position was that to even ask the question, are you 21?
Well,
have-
and that's why I specified a known individual, because I would distinguish the situation where you have this person who may or may not be 21. At that point, he knows that the smoking has happened. The question is the identity of the individual. So it reminds me a little.
But again, this is critical, right? For you to win, you need to be able to keep this conversation going, because otherwise you have a Cordero violation, right? So how are you?
Because the difference between reasonable suspicion and probable cause that would be a problem is if you can't tell the act happened. If you can tell the act happened, but the uncertainty is the status of the person.
You have both problems, because one, it's the guy is, I mean, based on the picture we have, he's not a kid. He actually turns out to be 27 years old. So in order for you to have an actual civil infraction, you need someone under 21 and you need the marijuana. But you've got, just seems like we don't get anywhere past that, because it's just so speculative at this point that, one, he's under 21 and you've got any reason to continue. And I just don't even know if I have to answer the question about probable cause versus reasonable suspicion.
It is true that in this sequence of events, anyone that ends the stop means that it ends the stop, and it.
You're dropping your voice, sorry.
Oh, I'm sorry. It is true that because this stop is sequential, the earliest step that fails is determinative. And this was an early step. However, I don't believe it does fail, because there was an admission that they were smoking marijuana. They said, we were smoking marijuana. And then the only question is this
But
person.
if it's you in the car or someone over 21, there's no infraction anymore. So I'm confused how it's reasonable to keep this going. You need to help me why Attorney Levin is wrong here, that when we don't know the age and it's a speculative civil infraction, you get to keep this going.
Well, the only thing that's speculative is about whether it applies to this individual, because
That's a big only, isn't it?
Yes, but but I think it's a legitimate thing to check the ID of something where the legislature could have legalized marijuana entirely, but it didn't. Instead, the legislature restricted marijuana so that civil infractions are between 18 and 21, and it's legal from 21 up. Now, it's possible they were trying to create some parallel with the alcohol laws. I don't know the full rationale, But by keeping this on the books in this matter, we have to presume that the legislature wanted some enforcement of this civil infraction, or why would they have had it?
May I ask you a question? It's a totally different topic. In your brief, the Commonwealth concedes that it failed to prove the absence of an FID card, but you only mention that bearing on the ammunition conviction. I'm wondering why that doesn't also require reversal of the firearm conviction.
I had not considered that question, Justice Wolohojian.
I-
I don't know. Would you permit a 60L letter on that issue?
Did the defendant admit that he didn't have a
I don't believe.
license to carry, or that was not admitted at trial?
It was stipulated.
It was stipulated.
It was stipulated as to no license to carry at trial, and the way the stipulation was written up did not include FID card, though it probably should have. The purpose of the stipulation was to avoid calling an extra witness and inconveniencing the parties.
What I'm trying to figure out is why doesn't this concession apply to both convictions? Because, and that's important to me because those were the items that were located in the glove compartment. So even if we got through all the other problems and we ended up examining the validity of going into the glove compartment, that wouldn't be in this case if the absence of an FID card got rid of, you know what I'm saying, just got rid of the convictions that depended on that evidence.
I don't know the answer off the top of my head, Justice Wolohojian. What I would like to do is go look at the statutes, because I suspect that one of the statutes has disparate sentencing for license to carry an FID card, but I'd like to confirm that before saying that.
I believe it was charged as, well, whatever, you'll check it out.
Okay, if that's okay.
Yes.
Thank you. If there are no further questions, the Commonwealth rests.